will come to order. I want to welcome everyone in the committee meeting room and following along online as well. Committee, if you will take a look at the minutes that have been distributed to you for February 8th, 14th, 15th, 18, and 21. Are there any suggested edits or changes to the minutes for those days? I don't see any. Do we have a motion to approve the minutes? Yes, Senator Thompson.
Yes, I move to approve the minutes as provided to the committee.
Thank you, Senator. Thank you, Senator. Do we have a second? Senator Gossage with the second. Thank you. Committee, any discussion? Seeing none then. You have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we will now open the confirmation hearing on Angela Kabul, judge nominee for the Kansas Court of Appeals. And want to explain the process a little bit and about what brings us to this confirmation hearing today. And just explain for the public and others following along. The business before the committee today is the consideration of the appointment by Governor Kelly of Angela Kabul as a judge of the Kansas Court of Appeals to serve subject to retention elections as set forth in statute, succeeding the Honorable Michael Boozer. KSA 20-3020 provides that any vacancy on the Court of Appeals is filled by appointment by the governor with the consent of the Senate. The clerk of the Supreme Court is required to give notice to the governor of any vacancy, and the governor accepts applications to the appointment and submits an appointee to the Senate for confirmation. To be qualified for appointment, the person shall have been regularly admitted to practice law in the state of Kansas and engaged in the active and continuous practice of law as a lawyer, judge of a court of record, or any court in this state, full-time teacher of law in an accredited law school, or any combination thereof for a period of at least 10 years prior to the date of appointment. Since KSA 20-3020 became effective in 2013, the appointment and consent procedure has been used 9 times, and the Senate Committee on Judiciary has held 8 hearings on appointees. Recognizing the importance of precedent in such historic matters, the committee will conduct this hearing in the same manner as the prior hearings. This particular committee that you see seated before you today has, in fact, this will be our 5th confirmation hearing procedure. So we have been diligent in our work. We have, I believe, a lot of us met and talked with the nominee. And so with that, I would invite Miss, and I'm sure I'm mispronouncing your name, is it Coble, Miss Coble? Sorry about that. Okay, well, great. I would invite first Ms. Coble to make any opening statement or remarks she may have prepared for today. And we'll allow 5 minutes so that we can keep our committee work on schedule. Thank you. Welcome to committee.
Thank you. Thank you, Madam Chair and members of the committee. I truly appreciate you permitting me to appear before you today. I also want to thank all of you and your colleagues in the Senate who took time out of this very busy legislative session to visit with me personally prior to the hearing this morning. As a constituent and a lifelong Kansan, I know how important your work is to the people of Kansas, and I appreciate learning more about your work on our behalf. As you know, my name is Angie Coble. I stand before you a proud, lifelong 7th-generation Kansan. I was born and raised in Rooks County, primarily in the small town of Stockton. My father and uncle were farmers, and their father a farmer. And my grandparents were really the hardest working people I knew. And they taught me and my siblings and my cousins the value of hard work and the importance of helping your neighbors whenever possible. Whether we were helping our Grammy prepare and serve harvest meals or riding in the truck with Grandpa to check cattle, it was in rural Kansas where I developed my strong internal work ethic and my desire to serve other people. In my childhood, I was introduced to our system of justice through the discomfort of a child in family court. This planted a seed in me, a desire to really one day become part of a solution to other people's problems. And although not one of my 4 parents graduated from college, of my eventual 10 siblings, I was the first to forge my own way to higher education and the only to seek a graduate degree. After high school, I attended Kansas Wesleyan University in Salina for my undergraduate education. And after meeting adjunct professor Judge David Knutson, then a district judge and later to become a Kansas Court of Appeals judge, my interest in a career in the law grew. As often happens, life shifted my plans, and rather than immediately pursuing law school, following college, I had the fortune to work in the clerk's office of the United States District Court of Kansas. There, I worked at the front counter of the clerk's office, and I first learned to read legal documents, communicate with attorneys, assist those without lawyers in filing their lawsuits. I interacted with multiple government agencies and judges, and I even was able to call in jurors and orient them to the system. Later, I served as a legal assistant in a one-lawyer law firm and was able to view legal practice from a small firm perspective. Those experiences would all later serve me well as a backdrop for both law school and my own private practice. I began law school at Washburn University as a mother of 4 young children when my youngest child started first grade. I commuted from Salina each day to Washburn my first year of law school, and despite those obvious challenges, through focus and hard work, I quickly rose to the top tier of my law school class. During law school, I developed my love for legal research and writing in classes and through my time on the editorial staff of the Washburn Law Journal. I spent a summer in a prestigious national law firm, which I was reminded daily included more people than in my entire hometown. And despite my positive experiences there, I decided to return to Salina to work in private practice in a mid-sized firm there, Kennedy Berkeley. During my years in private practice, I was able to represent individuals and businesses in litigation throughout the state of Kansas, in both state and federal courts. In my practice, I appeared in courtrooms frequently, and I understand the great responsibility lawyers and judges bear. I was also the primary brief writer in our firm, and I prepared many briefs to both the state and federal appellate courts. I was later presented an opportunity to become Chambers Counsel to a now retired federal magistrate judge, and my work shifted from that of advocating for my clients to that of the neutral perspective of the court. I've enjoyed putting my love of research and writing to work by providing legal advice to the judges with whom I've worked. I've researched cases from personal injury matters and employment matters to multi-million-dollar contract disputes, constitutional challenges, and criminal matters. One day I might review a criminal search warrant application in the morning and a copyright case or car accident dispute in the afternoon. And I have to date authored the drafts of more than 300 judicial decisions. And my interest in the law and becoming a member of the Court of Appeals is not just about solving legal disputes through research and writing. It really circles back to my desire to serve my community. Since I was old enough and capable enough to serve others, it's been a priority of mine to volunteer my time for the betterment of my communities. From early days in the 4-H club to serving on the local food bank, various legal, church, and parent-teacher committees, and more than a decade at our local community safety net medical and dental clinic, I've always and will continue to find ways to serve my fellow Kansans. I believe my experiences in private practice, representing many different types of clients across our state, and my experience in judges' chambers in a wide variety of legal matters and the writing of judicial decisions would permit me to hit the ground running as a Court of Appeals judge. If confirmed, I pledge to you I would set aside any personal or political biases or opinions and decide the cases before me with impartiality and on as narrow grounds as possible. I promise to uphold the U.S. and Kansas constitutions and decide cases according to the law written by you, our legislators, and respect the boundaries of our 3-branch system of government. I'm privileged to appear before you today and humbled by the process which I have watched unfold to bring me to this place. I look forward to answering your questions. Thank you.
Thank you. Thank you for those remarks. We will now offer each member of the committee an opportunity to ask questions of our nominee, and we will begin in alphabetical order like we have before. And with that, then we begin with Senator Baumgardner, who is not present. And we will allow each senator 5 minutes of question time. So again, we can keep the committee business moving forward. So with that, then we will turn to have any questions from Senator Bowers.
Thank you, Madam Chair, and welcome to the committee, Angie. And I have really nothing to ask you other just from one small rural farm kid to another. You've done really well. Very impressed.
Thank you, Senator. Thank you very much.
So keep up the good work, and
Thank you.
See you soon.
I've appreciated our time. Thank you.
Thank you, Senator. I keep forgetting. Senator Corson.
Thank you, Madam Chair. I have no questions. Thank you very much. And thank you for being here, though. Thank you, Madam Chair.
Thank you,
Thank
Senator.
you. Thank you. Senator Gossage.
Thank you, Madam Chair. And I just want to echo what the chair had said. We'd all met you in our offices and spent a great deal of time asking our questions then. But just for the listeners, I'm going to ask you a couple of questions that we talked about in the office so that they can hear your answers, if that's okay. Mm-hmm. One was, of course, we hear a lot about legislating from the bench. And that are you a strict constitutionalist where you look at a case to determine, is this constitutional? Where does this case fall? And can you give me your answer to that question if you were asked, would you legislate from the bench?
Thank you, Senator. Angie Kabul. And I appreciate your question, Senator. A couple of points that I would like to make. I mean, first of all, legislating in the Constitution is left to the legislators. The policy of our state, the will of the citizens should be expressed through their elected officials in the legislature. So in answer to your question, do I think it's appropriate to legislate from the bench? Absolutely not. Anytime we hear the criticism of legislating from the bench, that is an accurate criticism, because if the judiciary is attempting to make law, that's a divergence of the process, a divergence of our 3-branch system of government. And if the judiciary is attempting to make the law rather than allowing the legislature to work as intended, that confuses the law. That's how bad law is created. And it confuses attorneys who don't know what law to follow. It confuses judges, and it confuses the citizens of Kansas. And so in answer to your question, no, I do not think it's appropriate to legislate from the bench. And I would consider myself an originalist, a textualist, where I would look first to the Constitution and the written text of the statute when applying the law to cases, and not look outside that. And you use the word strict constitutionalist, and I think that we're really saying the same thing, that I would look to the text of the law and the Constitution and not outside that when deciding a case.
Thank you. Can you explain for the people who don't know, or non-attorneys, or they've never been involved in a lawsuit or ever been to court, the various levels of being a judge?
Sure. Thank you, Senator. Again, Angie Kabul. I think it depends. There are, of course, many different systems, legal systems. There's the federal system, the state system, but the state system in Kansas really, it has multiple levels. The district court level, which there are 31 districts in the state of Kansas. Some districts are made of only one county. Other districts, more rural districts, have multiple counties within those districts. Each of those districts have district judges. Each of those districts also have magistrate judges that their duties vary according to the wishes or the needs of that particular district. Most of the cases that would come before the Court of Appeals then, and I say most, originate in those district courts. If the litigants in the district court, if one of them is unhappy with how that case was resolved at the district court level, then they would file an appeal, and that would come before the Court of Appeals. If those litigants then are unhappy or unsatisfied with how the case is resolved at the Court of Appeals level, then they do have the option to appeal further to the Kansas Supreme Court. And again, if the litigants are unsatisfied with that resolution, they have the opportunity then to petition to the United States Supreme Court. And so that's sort of the progression of what the system looks like in Kansas.
And so your appointment would be to the Court of Appeals. Have you served as a judge in any of those other capacities?
Thank you, Senator Angie Coble. I have not served as a judge in the state court system or in the federal system. However, I have served as Chambers Counsel and provided legal advice to federal magistrate judges for the past 9 years. And in that role, I have had the experience of identifying a legal issue, identifying the dispute, researching the applicable law and applying that law in an impartial manner by authoring judicial decisions. And I may have mentioned in my closing, at this point in my career, I have authored more than 300 judicial decisions. So I feel like that experience really provides me a solid background for moving into a Court of Appeals position.
And my final question, Madam Chair, is if you were to serve as a judge on the Court of Appeals, you would be writing your own decisions, correct?
Correct. My understanding in conversations with current, sitting judges is that they do have research attorneys that assist them in preparing some research, but by and large, the Court of Appeals judges do author their own opinions.
And this is not a question, but you had shared with me that the Court of Appeals judges are in teams. Could you explain that?
Yes, thank you, Senator. Again, Angie Coble. The Court of Appeals has 14 judges, and they sit in, generally speaking, they can hear cases all together, but most frequently they sit in panels of 3, and those judge panels sit throughout the state. And on any given docket, on any given date in which the court is hearing cases, they may have 3 judges in the Judicial Center in Topeka, a panel of 3 in Wichita, a panel of 3, in Hayes or Garden City. And I think that's really important for a couple of reasons. One is that the court is really getting out into the communities across the state and offering litigants and attorneys. Not only does it save the citizens money in paying their attorneys not to have to travel so far, but the most important piece is that I think the court is accessible to the citizens and accessible to people across the state. And it offers, those 3-person panels offer a variety of perspectives. It's not just one judge deciding the matter. It's 3 different judges who are then able to share their own perspectives and opinions.
Thank you, and thank you, Madam Chair.
Thank you. Senator Haley, any questions for our appointee here today?
Thank you, Madam Chair. I was pleased that we did get an opportunity to visit with Ms. Coble. I appreciated this process and the discussion that we had regarding, in general, how she matriculated to this point. And I have been a fan and remain a fan, frankly, as I shared with Ms. Coble, having served in different capacities on this committee and others, of the process by which those who are truly vested in the dispensing of our legal system have come together, who, if you will, vet the vetting process of those who reach these decisions, independent of often the ultra vires input of a single person, an executive person. That process, as I shared with Ms. Coble and certainly have shared in previous incarnations of this process of confirmation, really holds most merit for me. Um, I'm not able to, nor are any really members of this committee often as able to come to the decisions as to whom might be in the best capacity to serve from the many applicants that are often brought. That having been said, I appreciate some of the questions that have come out. We've had these discussions before. What in the experience has brought a particular candidate to these positions to us. And I'm appreciative that, and I'm satisfied, at least in terms of my support, that those who are truly the practitioners within the law and those stakeholders, independent of political influence, have brought us the candidate they feel would be best served to be on our Court of Appeals. So it's no questions, just again an affirmation of the support that's brought you to this process, and I wish you Godspeed in that endeavor, Ms. Coble.
Thank you, Senator.
Thank you, Madam Chair.
Thank you, Senator Pyle.
Thank you, and I'll just echo the sentiments that already have been said, and congratulate you and your family on your success, and look forward to seeing what you do on the bench. Thank you.
Thank you. Thank you, Senator Pyle.
Thank you, Senator Thompson.
Thank you, Madam Chair, and thank you for being here, and also congratulations. We had a great discussion. One thing I might note is when we've had other conferees or other potential appointees, the scope of experience does matter, and I felt like in our conversation, and particularly what you pointed out this morning, your background in doing the research and working in a variety of different areas of law give you that the background. I guess the only question I would have, and I think I'm pretty satisfied with all your answers, with regard to your philosophy. Within the last couple of years, we've seen health mandates, things going on that trample personal individual rights. And I don't know if you have any specific thoughts on those issues. I know that's not something you may hear in the appellate court, but I think it speaks to your overall philosophy of law and individual freedoms with regard to the Constitution. Any thoughts you might have on that, I would appreciate.
Thank you, Senator. Angie Coble. First of all, I guess I would say that my personal belief is that our legal rights are really, they originate from the people. I mean, we are a government of the people, by the people, for the people, and the policies, the broad policy decisions for our citizens are then left to the legislature through our three branch system of government. And so my overarching philosophy then would be that the judiciary has to give deference to that three branch system of government, act with restraint, stay in their lane, if you will, and decide cases only according to the law as written, either in the Constitution or as written by the legislators in statute. And so my job as a judge, my job as a judge is to simply look at what the law is, apply it to the facts of the case, without, separating myself from any personal opinions or thoughts I might have about any particular issue, but to take that myself completely out of that and simply apply the law as written. And so that is my overarching philosophy, Senator.
Thank you. Thank you for that. I don't have any further questions. Again, congratulations to you and your family. And as Senator Pyle mentioned, look forward to seeing what you can do.
Thank you so much.
Thank you.
Thank you, Senator Wilborn.
Thank you, Madam Chair. Ms. Coble, thank you for being here. And I think about every accolade has been thrown your way. You've done a great job, and really appreciate your quest for public service and helping the public in general. I do have a quick question as relates to your practice. Was your practice balanced between civil and criminal, or pretty heavy civil? Because in the appellate court process, you'll be confronted with both.
Absolutely. Thank you, Senator Wilborn. Again, Angie Coble. My practice has been, and I sort of divide my legal careers almost into two separate careers, to be honest. So in my private practice, I was primarily a civil litigator. I was hired by the firm to litigate civil cases throughout Kansas. And so I did have very little criminal experience in that first of my legal careers. But in my career as chambers counsel, I have had many opportunities to apply both civil and criminal law, and in fact apply. Although I have been in the federal court, I've had many opportunities to apply Kansas state law in both the civil and criminal arenas. For example, the judges with whom I've worked handle criminal matters at Fort Riley. And so those cases, even whether they may be a DUI or a theft or assault or some sort of otherwise what would be a state criminal action, because those crimes are committed on post through the Assimilative Crimes Act, those become a federal matter. And so I have had the opportunity to apply Kansas criminal law to a number of those cases. And so although currently, I would say that my practice is probably maybe 80% civil, 20% criminal, and I recognize the Court of Appeals, that's flip-flopped. You know, the highest percentage, 70 to 80% of their cases will be criminal and a lesser amount of civil. So I understand that those percentages will be flip-flopped, but I do feel like my past experience in those matters will assist me, and just my history and experience and skill in research and writing will really allow me to get up to speed fairly quickly.
Thank you very much, and you have my full support. Godspeed to you and your family.
Thank you, Senator.
Thank you. Senator Baumgardner, any questions?
Thank you so much, Madam Chair, and thank you for being here today. You have talked about that depth and breadth of experience that you have. So share with us a little bit more on the importance of writing, which you did quite a bit of when you were a clerk. So what's the importance of that in the appeals court as a judge?
Thank you, Senator. Again, Angie Coble. First, as to the depth and breadth, I would just say that, in my private practice, again, I did appear in many courts across the state, which really provides me that background of understanding how our district courts function on a daily basis, and just allows me to identify with both the attorneys and the litigants in the district court, which will help me, I think, review the record as a Court of Appeals judge. And again, in my current practice as chambers counsel, that has really allowed me to really broaden the scope of legal matters that I've been exposed to. I think had I remained in private practice, I may have sort of been constrained to the couple of employment and domestic type matters that I was practicing then. But being in the federal court has really opened, being in the court system, you're exposed to every case that is filed. And so that is a huge range from federal criminal matters to, like I said, copyright cases and constitutional challenges, and even a car accident, perhaps between citizens of different states. And so I do believe that my breadth of experience in many areas of law will serve me well. As for the research and writing, that is just, it's a really comfortable environment for me intellectually. I enjoy really delving into an issue, digging into the research, trying to figure out what the law is that applies to that specific dispute, looking at both sides at the parties' briefs and deciding, seeing if their research is adequate, if I need to do additional research. And to me, that the writing process is where I best formulate analyze the issues. And so I've really enjoyed in my current position that sort of the solitary work of really just sitting down and spending hours digging into that issue and trying to resolve the problem. And so I think that's why I would be well suited for a position on the Court of Appeals, because that is what the judges on the Court of Appeals do in their daily work for the people of Kansas.
Thank you. Madam Chair, I have one more question. Really appreciated your resume that you provided. It was very complete, but share with us a little bit about Women Helping Women, a Fairy Godmother Fund, and your being designated a Fairy Godmother. Tell us about that.
Okay. Thank you, Senator. I appreciate that question. So Women Helping Women is actually a Salina group that was actually started by a group of women attorneys. And that group was really born out of what those women felt like was maybe a gap in different, current social services ability to really help people with things such as a single mom who's trying to get to work, but she has a flat tire and doesn't have the funds to buy a new tire. And so the Women Helping Women Fund was really an effort to rally other women in the community to create this fund where women can apply for grants. And it may be a $100 grant to buy a textbook for college, or it may be, like I said, a new tire. But it's really sort of a stopgap measure in our community to assist women who just sort of need a leg up.
Well, Madam Chair, I appreciate this nominee's breadth of experience, depth of experience. I also appreciate that when you were going after your law degree, you were that non-traditional student. And so you served as a role model and inspiration, not only to your children, but I think to others that wonder, should I take that next step? Can I take that next step? Can I be successful? And I think that you are spot on in those achievements and being successful. And I truly look forward to seeing how you continue to climb in your career while also maintaining those important values of family. So thank you so much for being here.
Thank you so much, Senator Baumgartner.
Thank you. And Ms. Coble, I have a couple of questions to follow up on that as well. And I think it's important as you're moving to a statewide level position, quite frankly. We have one Kansas Court of Appeals, and if confirmed, you will serve on that. So your decisions will impact the law across the state of Kansas. So it's important, and I am encouraged to see that you have breadth to your experience, you have depth, and you have variety. I think that's important because you are going to see all variety of cases if you are confirmed and serve on the Kansas Court of Appeals. You have stated that, I want to get back to one other thing. The Court of Appeals is different than your current position in a district court, which is a trial court. So I'm also encouraged to hear that you enjoy the writing process, which is often what we see, quite frankly, in the Court of Appeals, because the Court of Appeals does not have witnesses come in who testify. There's generally no new evidence provided. There's no determination of credibility of witnesses, as if you were sitting as the finder of fact at the time with the witness testifying in front of you. It is all on paper. And that's important to know that you enjoy the writing process and the research process, because the work of the Court of Appeals is often documents and document review and research. So it's good to hear that it sounds like it's something that you enjoy as well. I wanted to ask a question about, you said you have been involved with writing 300 plus judicial decisions. And we've also heard some about your judicial philosophy, if you will. So when we look at the rule of law and applying the law to facts, the law is the law, and the law determines a particular outcome if you follow the law as you apply it to those particular facts. So could you talk to the committee for just a moment, if you can think of, and we talked about this a little bit in our conversation in my office the other day, if you had one decision that you looked at the law, you researched the law, and the law came out as you applied it to the facts of the case before you, in a way that maybe diverged from your own personal opinion about what you would like the outcome to be and what that case was, and you nonetheless, in advising the judge that you work with, Judge, this is the law, this is how it applies the facts. Maybe I personally don't agree with that outcome, but we have to apply the rule of law, and here it is. If you could give us that example, if you can recall it, that the outcome, you stuck with the rule of law, and even though it might have disagreed with your personal outlook. Thank you.
Sure. Thank you, Senator Angie Coble. I think one of the opinions, and I think Chairwoman Warren, we talked about this in our meeting. One of the opinions that I can think of off the top of my head, it was an opinion that was signed by Judge Berzer, but it was an opinion denying the U.S. Attorney's request to delay notification of the service of a search warrant. And there was a law requiring that the government must notify the target of that warrant within a certain number of days after the warrant was executed. And there was a procedure also in the law for the government, if they wanted to delay that notification, there was a procedure that they were required to go through to request that delay be approved. In this particular case, the notification had been delayed on multiple occasions, and there were other cases in which delayed notification was requested after the time had already expired. And so there was an analysis of whether or not the expiration of that period was due to some excusable neglect or whether it was simply an error on the part of the government. And in this particular case, it was very clear that it was an error and not an excusable situation. And so while I personally had a little bit of angst about requiring the government to disclose the service of this warrant on a pending criminal investigation, it was what the law required. And so in that circumstance, what I really appreciate about my current job, and I think will translate well, is that the judge and I were able to sit down, visit about that situation, exchange viewpoints, and if I am fortunate enough to be confirmed on the Court of Appeals, as we discussed, there will be at minimum a 3-person panel that will be able to discuss and exchange views on how the law should be properly applied. And so in that instance, and in any instance in which a dispute was before me, I would set aside my personal feelings about how any particular dispute should turn out and simply apply the law as written.
Thank you. Appreciate your answer. And another question about a favorite judicial decision that you helped author or you helped advise on. Could you tell us a little bit about that?
Thank you. Thank you, Chairwoman. Again, Angie Coble. I think we discussed, and I think I've discussed with a few of you about, it's hard to choose from that many judicial decisions on which one I could really say is my favorite. As I said, I really just enjoy the writing process.
And if I could narrow the question just a little bit,
Yeah.
how about the decision that best exemplifies your judicial philosophy or how you analyze cases? If you can narrow it down to one
Sure.
example,
Actually, I think I would go back to that delayed service.
that same one.
Yeah, I think I would go back to that one, just demonstrating the importance of adhering to the rule of law.
Well, great. I appreciate your time with the committee. Do we have any conferees in the committee meeting room who wanted to say a few words, or on WebEx who wanted to say a few words either in support or opposition of the appointee here today? I don't see any in the committee meeting room, and we don't have any on WebEx. We don't have any on WebEx either, so just confirming that. And do we have any other committee questions for the appointee? I don't see any either. And Ms. Coble, Ms. Coble, I will get that right by the time we're done here today. I apologize. Ms. Coble, do you have any short closing comments you would like to make to the committee?
Sure.
Keep it to 1 or 2 minutes if you would, please.
Sure. Thank you, Chairwoman Warren. Angie Coble, I would just really like to thank all of you again for your time and efforts in reviewing my materials, taking time from your work and families to meet with me before today. I know a couple of you, I think I ran down in the hallways, so I really appreciate you taking that time to spend a few moments with me, both allowing me to describe to you what I felt like my qualifications are, but also you educating me on the work of the legislature and your desires, and what you would like to see in the judiciary. I really appreciate that each of you took that time. I discussed with some of you in our meetings how this process has really benefited me by furthering my education about the important work of the legislature. And I want you to know that if confirmed, I will continue to respect the diligent work of the legislature in setting the policy for our beloved state. I've worked very hard to arrive at this place, from learning about the legal system through a myriad of personal, employment, educational experiences during both private practice and in my work as Chambers Counsel. I'm confident I can use the skills and the knowledge I've gained to work with you, the legislature, to serve the people of Kansas. If confirmed, I'd be a judge with not only legal acumen and research and writing skills, but a judge with a depth of human experience, which I would be honored to put to use in our appellate court system. I pledge to treat every litigant fairly and hear each case before me with an open mind and apply the law as written, with the federal and state constitutions always in the forefront. So thank you again, Madam Chairwoman, and members of the committee, for your time and diligence in this process.
Thank you, Ms. Coble. It has been the practice of the committee in considering judicial appointees in a single day to take a 15-minute recess before committee discussion and action to provide members with a final opportunity to review the materials in your packet and the testimony presented today. We have heard through questioning that it sounds like we have quite a lot of support that has been stated already by the committee members. So we are going to take up any committee discussion. You go ahead and have a seat, Ms. Coble. Appreciate that. Any committee discussion and entertain any motion on the appointee now rather than the need for a recess. Senator Gossage.
Madam Chair, I move that we waive the traditional 15 minutes and go ahead and make the motion that we approve this appointment favorably out of committee.
Let's make that in 2 separate motions if we could, just to keep our reviser happy, if you will, and to be procedurally accurate. So if you have a motion that we go ahead and discuss and entertain another motion at this time, that would be the motion then, correct?
Yes, ma'am.
And we have a second from Senator Baumgardner. So the motion is that we go ahead and discuss and entertain the confirmation discussion on Ms. Coble right now. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. So then we are discussion and any motion on the confirmation of Ms. Coble. And we do have a particular form that we need to state with our motion. So for the committee's consideration, after we have discussion, I will ask for a motion from the committee regarding the appointment. And the possible motions include, I move the committee recommend the appointment favorably for confirmation by the Senate, excuse me. Another possible motion is I move the committee recommend the appointment be not confirmed by the Senate. And a third possible motion is I move the committee report the appointment to the Senate without recommendation. So those are the three motions, and I will help repeat them to you if you did not get the wording exactly correct. So any discussion or motion? Yes, Senator Gossage.
No, I'm just kidding. I move that we recommend to the full Senate the confirmation of this conferee favorably.
Thank you. Just to repeat the motion, is it this? I move the committee recommend the appointment favorably for confirmation by the Senate.
It is precisely that.
It is. Well, wonderful. Do we have a second? Senator Baumgardner.
Thank you, Madam Chair. I second that motion without reservation.
Thank you. We will now entertain discussion on the motion. Any discussion on the motion? I wanted to briefly comment that I appreciate the experience and the variety and depth of that experience that Ms. Coble, you have brought to the committee today, and your vast legal career and your personal biography as well. We learned about that in your resume and in the discussions that we've had, and your practice on the trial court level and what you have done there, and your discussion about how you would conduct yourself on the Kansas Court of Appeals is admirable as well, and your preparation for today. And I know it's a long process to get to the confirmation hearing today, and appreciate your efforts and your perseverance in that regard. And want to then open it up for a vote on the motion. You all have heard the motion then all those in favor signify by saying aye. All those opposed? I am proud to announce that the motion carries. So congratulations, Ms. Coble, and you're welcome to stay and see how the rest of our day is usually conducted, with a hearing on a constitutional amendment that's been sent over to us by the House. So I want to again thank you, and for your family, if you want to state briefly who's here with you today, you may approach the podium and introduce the family you've brought with you.
Sure, thank you. I appreciate, Chairwoman Warren, the ability to introduce them. And I will say, I know that my mom and my stepdad are listening at home, and probably a number of my 10 siblings as well. And so who I have today is my husband, Mark, who has put up with a lot. I'll just say that. Super supportive. My youngest son, Trevor, who is here from Manhattan. One of our daughters, Sophie, who is, she lives in Lenexa, and she has our beautiful granddaughter, Julianne, who will turn 2 on Friday, and she will be giving us another grandchild in a matter of weeks. So we're very excited about that. Also, my good friend, college roommate, Jenny, and her husband, Larry, who live here in Topeka, came to support me today. And again, thank you for allowing me the opportunity to acknowledge those people, because I certainly would not be here today without the support of my family and friends. So thank you very much.
Absolutely. Well, welcome to committee. Thank you for coming today to the hearing, and you're absolutely right. Family is very important, and our support structure, and appreciate them being here today and the long road that they have traveled with you to get here today. And then we will send your recommendation from the committee that you be confirmed by the Senate as a whole. That will come up for a vote by the Senate as a whole. I do not know which day that is, but you're welcome to contact my office, and any information I have to pass along to you, what day that might be, I would be happy to share with you. So thank you again for coming and for being part of the confirmation process here today. So with that then, committee, we will close the confirmation hearing on Ms. Angela Kabul for Judge, Kansas Court of Appeals, and turn our attention and open the hearing on HCR 5014, which is proposing a constitutional amendment that provides for legislative oversight of rules and regulations adopted by executive branch agencies and officials. Committee, this mirrors a Senate resolution that we heard a couple of weeks ago, and we will invite the reviser for a bill brief. Thank you.
Thank you, Madam Chair. Members of the committee, this should sound very familiar to you all. This is a bill brief for House Concurrent Resolution 5014 that would add a section to the Constitution of the state of Kansas relating to legislative oversight of administrative rules and regulations. And as mentioned by the chair, this would mirror the Senate concurrent resolution that you heard from me a few weeks ago. And the current rules under current statute requires the Joint Committee on Administrative Rules and Regulations to review all proposed rules and regulations during a public comment period. After each meeting, that committee issues a report with comments and concerns about those rules and regulations, and the committee may introduce legislation to propose in response to proposed rules and regulations, but it cannot require changes to or reject any of those rules or regulations. The concurrent resolution would add Section 17 to Article 1 of the Constitution to provide that when the legislature has authorized administrative regulatory authority, the legislature would have the authority to revoke or suspend any such rules and regulations adopted under that authority or any portion thereof if there is a majority vote by both chambers, and that revocation or suspension would not require the governor's signature to go into effect. And as with all concurrent resolutions proposing amendments to the Constitution of the state of Kansas, it would have to be adopted by a 2/3 vote in each chamber in order to be presented to the general electorate for approval. And if this resolution were adopted by the constitutional majority in both chambers, it would be submitted to the electors of the state at the general election this November. And I'll be happy to answer any questions.
Thank you. The first question I have is, please identify yourself for our record.
My apologies.
That's all
Jenna
right.
Warner, Office of Revisor of Statutes. I got too excited about briefing this resolution for you.
Well, thank you, Ms. Moyer. Appreciate that. Committee, we are having a paper copy of the resolution delivered to committee momentarily, so I realize we don't have that yet, but we are bringing that up. In the meantime, do we have questions for the reviser? Senator Pyle.
Thank you, Madam Chair. Can you tell me what was the vote on both occasions? I understand this took a couple votes to get it through the House.
Ms. Moyer?
I don't have that number in front of me, but I'm guessing that Jason is looking that up right now. I know that the first vote was just short of a constitutional majority, and then the second vote, they just got past it.
Mr. Thompson, go ahead. Thank you.
Thank you, Madam Chair. Jason Thompson, Revisor of Statutes. So final action on February 17th, the vote was 80 yay, 33 nay. And then a motion to reconsider was adopted on February 21st. That was Monday, February 21st. And final action was yay 85, nay 39.
Thank you. Committee, go ahead, Senator Pyle.
Jason, on procedure, so February the 17th to February the 21st is 4 days. How did that motion to reconsider apply since it laid so long? I thought that was, just explain please why it wasn't a 24-hour limitation.
Go ahead, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. So that was a Thursday to a Monday. So I'm assuming on Friday they must have been pro forma or otherwise not had action, so that the next business day was the Monday. So procedurally, that's how it must have worked out.
Thank you.
Committee, other questions for the reviser? Seeing none, then we will hear from our conferees. Committee, we have 5 in-person or WebEx conferees, and with the time remaining, we're going to have 5 minutes of testimony from each conferee, And we will start then with our first proponent in-person conferee, Elizabeth Patton, Kansas State Director, Americans for Prosperity. Please introduce yourself and welcome back to committee.
Thank you very much. Elizabeth Patton, State Director for Americans for Prosperity. Thank you so much for having me here today. We have testified in favor of this before the committee, so I will be brief and just want to make a few points, and then I would be happy to answer any questions from the committee when appropriate. But the gist of this policy, I did want to point out that the vote in the Kansas House was actually bipartisan. And from our perspective, this just really sets right what was put wrong by a bad court case several decades ago. We think that by making this adjustment, we can strengthen our economy for years to come. And it's a great opportunity to have pro-growth reform for our state. I think I mentioned in front of committee last time to think of improvements to our regulatory environment in Kansas as economic development. And we think that is very much the case for our state when you think of long-term transformative policy. We do hope that the committee chooses to allow the voters of Kansas to make this decision, but we think this resets accountability in our state in a net positive way for not only the agencies, but also the legislative process and the people of our state. I want to read to you a quote really quick from a Forbes article that came out around the time that this was being voted on in the House. And it mentions Kansas several times, but in my written testimony, it is referencing some of the Mercatus research that I have provided the committee. But this quote in the article, if you will allow me, if Kansas reformed its regulatory environment, it would cut costs for consumers and expand opportunities for entrepreneurs, both today and long after inflation has passed. States such as Florida, Texas, and Utah are showing the rest of the country what strong, dynamic economies look like. And it goes on to talk about their tax, but at the end of it, it says governors that create similar regulatory environments in their states will generate enduring economic prosperity. And that final quote is what I want to leave you with today, is that we believe this amendment will help us down the path of leading to enduring economic prosperity for our state. Thank you, and I would be happy to stand for questions.
Thank you. That was 2 minutes, but thank you. It was brief. And we will go ahead and save our committee questions till we hear from all the proponent conferees. Thank you. We will next invite Eric Stafford, Vice President of Government Affairs, Kansas Chamber, to the podium. Please introduce yourself and welcome back to committee.
Good morning, Madam Chair and committee members. Eric Stafford, Vice President of Government Affairs for the Kansas Chamber of Commerce, here in support of HCR 5014. Again, reiterating what Elizabeth said, that you guys have heard this in the Senate version before. I think that was 1618 or 1612 HCR or SCR. But really, this paired with Senate Bill 34 that passed the Senate last week before turnaround, I think is a good combination that will provide very strong regulatory reform and a strong regulatory climate for the state of Kansas. Senate Bill 34 that passed provides a periodic look back and fast track repeal option for state agencies. So we're constantly reviewing rules and regulations. To Senator Pyle's questions, good question on what the vote was and kind of how it broke down. The first vote that took place on the House side, there were quite a few members of the House who were gone on the first vote, whether it was illnesses or absence, whatever. But that's why they ultimately ended up having a revote, just because there were, I think the total vote, they were 11, 12, 15 members short. So that's why it went again on Monday. So, but again, as Elizabeth said, bipartisan support for the bill that dates back to a court case of Stephan versus the House, Senate, and Governor Carlin. We ran into that case in 2018 when we were pursuing legislation known as the REINS Act that would have provided the legislature the ability to repeal or reject regulations. And the reviser at the time, we testified on a bill that we did not introduce, but offered an amendment. And the reviser at the time said, yeah, we can't do, you can do the economic impact statement from the agencies, but you can't do the legislative vote because of this court decision. And kudos to our revisers who have that knowledge and historical record as to why that was impossible. But this Constitution amendment introduced by the Attorney General of the state would fix that. So we are definitely in support of it, and I'll be happy to answer any questions. I will say I have to leave here in about 5 minutes to leave to another appointment. So appreciate the opportunity to speak in support of this today, and good to see you all.
Thank you. Are there any other proponent conferees in the committee meeting room or online? Seeing none, then committee, please turn your attention to your committee folders. We do have proponent written only testimony from Jackie Newland.
This is Tad Kamar. Hello.
I'm sorry. Yes. Who, please? I'm sorry, who? That's opposition, Mr. Kramer. We're on proponents. We will get to you in just a moment. Thank you. We have proponent written only testimony from Jackie Newland, Associate Counsel, Kansas Livestock Association, Alex Orell, Senior Vice President, Government Relations, Kansas Bankers Association, Derek Schmidt, Kansas Attorney General, State of Kansas, Office of the Attorney General, Shahira Stafford, Stafford Public Affairs, LLC, on behalf of the Kansas Cooperative Council, Randy Stuckey, Senior Vice President of Government Affairs and General Counsel on behalf of the Kansas Grain and Feed Association, Kansas Agribusiness Retailers Association, and Renew Kansas Biofuels Association. And from Jason Watkins, Watkins Public Strategies, on behalf of Wichita Regional Chamber of Commerce. I believe now all the proponent written only testimony has been distributed for your committee folders except for the proponent written testimony from Ms. Jackie Newland and from Mr. Jason Watkins. They are available online, however, at this time. With that, committee, then we will open it up for questions for our proponent conferees. Are there any? Seeing none, then we will ask for any neutral conferees in the committee meeting room or online. Seeing none, then we will ask our first opponent in-person conferee, Zach Pistora, State Lobbyist, Kansas Sierra Club, to come to the podium. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. Zach Pistora, proud lobbyist for the Kansas chapter of Sierra Club. We're a nonpartisan, nonprofit organization representing nearly 5,000 members across the state of Kansas to enjoy, explore, and protect the great outdoors of Kansas. And we have a national membership as well. We appreciate the opportunity to testify in opposition of HCR 5014. You heard what it would do. We take this issue of changing the Kansas Constitution very seriously, and we're thinking about it a little bit, and we understand that many of the environmental protections to protect our air, water, land, and our communities are promulgated by yourselves at the legislature, but they're implemented and further detailed at the rules and regulations level. And so we're concerned that these agencies that are normally insulated from political pressure, long time, many instances, dedicated servants that have been serving multiple administrations and have one specific single mission, and that's the mission of the agency as their special interest. And that's to maintain the current process of developing rules and regulations without this cloud of veto power. And so that's our main point. We'll say that for 40 years now, this current process of the rules and regulations has been tested and trued over the years. There is opportunity for the legislature to weigh in through the Joint Committee of Rules and Regulations. There's also, at that point, they get a chance to debate the specifics, offer questions or guidance to the agencies as the rule goes forward. And if the legislature feels that any rules and regulations are inadequate, they can come back, they can specify the change in the law. And if any private entity feels like the rules and regulations are inadequate, they can take, that entity can challenge the rule in our court. Our main concern is this. We are worried that the power by the legislature to revoke or suspend the rules and regulations could increase the political pressure and by powerful special interests seeking less regulatory scrutiny upon their industry or business. I think it's important to point out that this concern isn't just hypothetical, but if you look who's supporting the change in the law, often they're pro-industry groups, less concerned about the balance of regulation protecting the environment, for example. If HCR 5014 is approved, it could distort our rules and regulations process by giving more ability for moneyed interests and corporations to persuade their backed elected leaders toward narrow favors. Okay, so that's main. We hope this won't come into fruition, that this wouldn't actually happen, but it is a worry that we could increase the political pressure, more micromanaging and scrutiny of our rules and regulations, when right now that process is, those agency officials and bureaucrats are mainly insulated because they have the single mission of the agency. So thank you very much for hearing our concern. We would say that there's a lot of risk involved with passing this constitutional amendment, of course approved by the voters, but not as much reward. So we'll stand for any questions. Thank you.
Thank you. We will have committee questions after we've heard from all the opponent conferees. Thank you. We will next invite Celie King, Advocacy Chair, League of Women Voters of Kansas. She is appearing via WebEx. Ms. King, are you online?
I am online. Can you hear me?
Yes, please introduce yourself and welcome to committee. 5 minutes. Thank you.
Thank you. I'm Celie King. I'm Advocacy Chair for the League of Women Voters of Kansas. The League does oppose this bill, this concurrent resolution, because we think it blurs the line between legislative and executive branches of government and makes it more difficult to administer the laws of Kansas. Currently, the Kansas legislature, when it approves a law which instructs the executive branch to develop rules and regulations, there are a number of checks. The suggested rules are checked by the Division of Budget for Fiscal Impact. Then the Attorney General determines if there are constitutional issues. Then thirdly, the Secretary of State office checks for technical and approved form. After these 3 steps are completed, the proposed rules and regulations are put into a Kansas register, and then a required public hearing is set for final adoption. These steps assure that all avenues are checked for cost, legal correctness, and technical form. If the legislature feels that the proposed rules do not meet the intent of the legislation, then the legislature can pass a replacement law, which more clearly states the intent of the legislature. We wonder, and has it been discussed, if this did pass, would this be retroactive and that the legislature could override any set of rules and regulations that are already in place? And it's unclear of how this process will be triggered. Will a process be put into the House or Senate rules? Can a requested Attorney General opinion be enough? I assume the Joint Committee on Rules and Regulations will be the primary avenue, but we talk about the uncertainty for state agencies and a changing definition of intent of law, paralysis, and the confusion that would create. So again, we think there are a lot of problems with this. We agree with most of the comments from Zach Pastoria for the Sierra Club, and then ask that the committee vote no on this concurrent resolution. Thank you very much. I'll stand for questions.
Thank you, Ms. Klein. At this time, we will hold for questions and we'll go to the next conferee. Please stay online. There may be a question surface after Mr. Ted Kramer is up now. Is he on the WebEx? Yes. Just please identify yourself and please proceed.
Madam Chairwoman and honorable members of the committee, I am Tad Kramer, a retired business and regulatory law attorney living in Big Springs, Kansas. Thank you for the opportunity to testify in opposition to HCR 5014. This bill would give the Kansas legislature, by simple majority vote, sweeping authority to revoke or suspend any rule or regulation of any executive branch officer or agency. It would eviscerate the delicate checks and balances among the three branches of government and usurp the executive power to administer and enforce laws contrary to the fundamental American doctrine of separation of powers. Kansas courts have upheld the separation of powers as an outstanding feature of the American constitutional system. Each of the three branches of government has its own responsibilities and powers, and one branch should not extend its own powers to interfere with the operations of another branch. Legislative power is the power to make, amend, and repeal laws. Making rules and regulations is substantially a function of administering and enforcing laws. Rules are generally adopted after an extensive rulemaking process involving public input. Rules add the details needed to administer and enforce laws. The legislature deals with a vast amount of proposed legislation in a limited amount of time, which makes it difficult and inadvisable for the legislature to delve into the level of detail needed for rulemaking. Giving the legislature the power to revoke regulations would be micromanagement of the executive branch and significantly interfere with its ability to administer and enforce laws. It is an attempt to gain direct control over delegated administrative power. Other actions can be taken to address this issue that do not violate the crucial separation of powers principle. If an affected person believes an agency rule goes beyond the agency's authority, that person can sue the agency and the court can invalidate the rule if appropriate. It is also possible for the legislature to amend the relevant law to clarify the matter in question. HCR 5014 would micromanage and interfere with the operations of the executive branch in violation of the essential American doctrine of separation of powers. Please oppose HCR 5014. Thank you for your consideration. I will be happy to answer any questions.
Thank you, Mr. Kramer. Do we have any other opponent conferees in the committee meeting room or on WebEx? Seeing none, then committee, any questions for the opponent conferees? Yes, Senator Haley.
Thank you, Madam Chair. Either Mr. Pastora or those who are online. First I should say that I actually see some potential merit in the HCR. I guess my concern is, my question for them might be, procedurally now, the legislature is able to affect the executive's decision, an executive's decision with 2/3 of a vote. I guess my biggest concern, or my question to you, is this is a majority. This would be just a majority of the legislature. Would you feel, I think, more supportive of what the HCR purports to do if a review or the micromanaging, I think is a good word, of an executive decision were to be held to the 2/3 or the constitutional majority to affect that? Would that ease, I guess, some of the concerns you've expressed, or not?
Please introduce yourself and thank you for answering the question.
Thank you, Madam Chair. Zach Pastora from the Kansas Sierra Club, and thank you, Senator Haley, for your question. Yes, there is a greater level of comfort with a 2/3 majority. I think what happens is that it rises to a really significant and compelling state of objection from the legislature on a rule or regulation versus just a simple majority. So I think it causes a little bit more. And again, the more we can stay with our current system, we feel more comfortable with. Because we haven't seen that political maneuvering for overchanging rules and regulations, at least in our view, as a parent, with having that established 2/3 majority versus a simple majority. So I hope that answers your question.
Well, it does, but so if this were changed to reflect that, would that take your opposition?
Would that ease
out?
our
Right,
concern?
exactly right. Yes.
Again, we wanted to offer the objection on the proposed legislation because of this worry about micromanaging. It would certainly ease our concern because of the higher threshold. We just hope that this wouldn't be the case. And I just would say that we didn't hear much cause from the proponents of what regulations were causing concern right now. And so I think that's important. You heard about, easing roadblocks for economic prosperity and growth, but, it's an opportunity here to put forth good ideas in front of you as the legislature and have that be enacted. We'd say the legislature's done a good job of economic growth, right? But for the fine print to stay insulated at the rules and at the agencies by the bureaucrats, I think are better. So yes, we'd have less concern with a 2/3 majority, to answer your question.
Thank you. And thank you, Madam Chair. Unless anyone else online, any of the other opponents have anything different, I'm fine. Thank you, Madam Chair.
Do we have any?
Can I mention something? Yes, this is Tad Kramar. Yes, please. Yeah, I would still have some concern that it would be a violation of the fundamental American doctrine of separation of powers. There are, like I say, there are other means that that can be used if an agency oversteps its authority. And this should still be, even if it's a 2/3 majority, it's still legislative interference in the rulemaking process. Thank you.
Thank you. Thank you, Madam Chair.
Yes. Any other questions from the committee? Senator Thompson.
Thank you, Madam Chair. With regard to any of the opponents, to me, the legislature grants the authority to these agencies in the first place. And I'm just looking again, I keep referring back to the pandemic because it's very fresh in our memory. There were some agency rules coming down that shut down businesses, shut down churches, shut down all sorts of things. And how would you propose with the speed, the glacial speed at which the legislature can move at times, that we remedy these situations other than with a resolution of this nature? Because I certainly don't see any kind of remedy at all. In fact, we're still dealing with some of the residual effects of mask mandates and things of that nature on schools. So how would you propose that we fix some of these situations other than give it to the will of the people through the legislature? And anybody who'd like to answer that, I appreciate.
I was going to ask, Senator, is your question directed to a particular conferee? Or?
Whoever would like to answer that. Thank you, Madam Chair.
Thank you. Do we have a conferee who would like to answer that question?
Yes, I would be happy to answer. Others could answer too, that's fine. But this is Tad
Hold
Kramar.
Hold on a second. Please identify yourself and then go ahead and answer the question. Thank you.
Yes, this is Tad Kramar. Yes, I would say the legislature does have the ability to amend laws to clarify situations. So if they thought the agency was overstepping its bounds, they could pass a law that would change, that would spell out what can be done and what can't, go into more detail. That would be the same kind of procedure pretty much as enacting a resolution to overrule the agency. They could do it by a law instead. I think that could be done just about as quickly.
Thank you. Committee, other questions? Senator Thompson?
No, thank you. I respectfully disagree on the speed of this, but I appreciate the response. Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none, then we will go ahead and close the hearing on HCR 5014 and thank the conferees for appearing in committee and online as well, and for those who have submitted testimony as well. Committee, we have a busy day tomorrow. We have many conferees, not quite certain how many will be in person, but we do have an informational hearing scheduled for tomorrow, and then another informational hearing on selection of Kansas Supreme Court justices for Friday. However, please keep an eye out for a revised agenda. If we have referral of bills or resolutions to committee that are still coming over from the House and that have been introduced in Fed and State Committee that are being referred to our committee. So please keep an eye on, like you do, the agenda that might be revised and coming out soon. So with that, committee, thank you for your work today, and we are adjourned.